Ancestry.com refusing to comply with a search warrant to open up its DNA database. Police have been using new methods to help solve crimes, tracking suspects through the use of family DNA, but the company has vowed to keep the genetic data of customers safe. Joining us now is David Bruno, a criminal defense attorney. Good morning.
Good morning, guys.
So why does the court want this info?
Well, not the court. It's law enforcement. Generally speaking, law enforcement has a job to do, right? And I'm a former homicide prosecutor myself. Sometimes we develop DNA profiles at crime scenes and have no suspects. So I think what law enforcement is trying to do is get into the Ancestry database because they have the DNA profiles from individuals trying to put family trees together. So in this particular case, it's a Pennsylvania case where there was a search warrant for this information. And Ancestry published this transparency report from 2019 that said that we did not provide the data. So they say, no, even with the search warrant, it's in fact defying a court order if they want to go that way. And that's why it would go up the chain and all the way up to the Supreme Court one day.
So what's the biggest hurdle for police here?
The biggest hurdle is the Fourth Amendment. The Fourth Amendment of the United States Constitution provides against unreasonable searches and seizures. What that means is when there's an expectation of privacy, like, for example, this database, police would have to get a search warrant. And when you get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place. So that's where I think the biggest hurdle would be. For law enforcement to say, hey, we have probable cause that the DNA profile that matches is in the database. Other than that, it's a fishing expedition. And they would be able to get warrants whenever they can.
And this would be a major resource considering this holds 16 million DNA profiles.
Absolutely. Major resource. There's a CODIS, there's a law enforcement database where law enforcement proactively gets DNA profiles for convicted felons. And in that particular case, that's why they get the DNA profiles, not for ancestry, not for family trees. That's why I think there should be a stopgap by courts and judges to say, hey, if you don't have specific probable cause that this DNA profile is in the database, then there should not be a warrant.
So might it go all the way to the Supreme Court or no?
Well, there's no real track right now. This Pennsylvania case did not lead to any appeals, but I think ultimately it will. I think this issue, front and center, should be in the Supreme Court. Also, cell phones. We hear about the terrorist in Florida, where Apple is refusing to comply with law enforcement to crack.
San Bernardino, California case.
San Bernardino, you go on and on and on. So I think in search and seizure jurisprudence, ultimately we're going to have to get an answer to these DNA databases as well as whether or not to crack phones.
So they search for the genetic profiles that partially match DNA from crime scenes, and then they build the family tree from those relatives to find the suspect. So again, it could be a major resource, but those companies want to protect the privacy.
Sure, we should all have expectation of privacy when we go and we deliver our DNA to this company, that it won't be used.
Appreciate it.
You got it, guys.
Thank you, David.
Pleasure.
Fox News Alert.